I am Anne Elizabeth Hussein, an attorney at law. I practice in Guyana. This is a country in South America. Today, we will be looking at, in terms of wills and estates, the relationship to the COVID-19 patient or the COVID-19 deceased persons, particularly in relations to accessing their money, accessing their financial arrangements, accessing financial institutions. Of course, the COVID-19 patient would be in home isolation or quarantine, or they would be hospitalized and they were unable to do their day-to-day transactions, to pay bills, to pay medical expenses, to simply go to the supermarket and live. They need money. So they would be able to make use of their credit cards or their debit cards, yes, but to actually physically enter into the businesses to access their financial arrangements, you would need to think about a living power of attorney. A power of attorney could be very limited, and you need to visit a lawyer office to prepare a limited power of attorney. A power of attorney would allow the patient to give someone trusted the responsibility of entering, for instance, the bank to deposit, to save any monies that they may have, or to withdraw, make huge withdrawal sums that would exceed the daily cash limit. Or they can simply use a letter of authorization. They themselves can prepare a letter of authorization to someone to enter into the financial institutions, the banks, and to conduct their transactions on their behalf. But all banks may not utilize the letter of authorization. You can have a letter of authorization to take to the workplace in order to have someone uplift their employment check or their salary wages if it is not going directly to a bank account. You would also need to access your monies in institutions, as I said, to pay medical expenses. It is being provided, the one in the hospital care is provided by the government free. It's a public good. So there's no expenses there, but there will come a time when COVID-19 will be endemic, and being endemic, treatment may be proliferated into the private sector, meaning that private hospitals would provide the care for patients, whether severe or less symptoms, and insurance can be lodged or claimed at a later date. But you would need to have money upfront to pay for these treatments. So in those cases, you would need to consider the power of attorney or the letter of authorization. What also the patient would need to think about is making a will. And in making a will, it allows for a representative to be named as an executor. It makes it easier for the executor to go to the registry and apply for a letters of probate. One need a letter of probate in order to access your bank account and your financial arrangements. So with the representative would need monies to pay for your funeral or expenses and other liabilities or debts owing. The representative would need the letters of probate. If you do not have a named executor or a will, well then the person would have to apply for letters. A person that would be a beneficiary rather would have to apply for letters of administration. you would need to visit the office of an attorney to prepare a will for you, and they would explain better what are the things you would need to think about. Of course, but if the person passes, the COVID-19 patient passes, the banks would allow a sum of $150,000 to pay for funeral expenses. A letter would be drafted up with any bills that may have been retained to be submitted to the bank for payment. Of course, this is discretionary and it is subject to the estate being very small. I would like to note that small estates goes through the same rigor as large estates with property, land and house. The system in Guyana is very convoluted, and you may like and subscribe to hear further informations regarding the convolution and the issues or the repetition in the system of administration in Guyana. Again, please like and subscribe and share if you would like to hear more content or have any questions. Please see the link below for our contact details. Thank you.